Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy by TrustArc. Please welcome our hosts, Paul Breitbarth and Kay Royal.
Hi everyone, welcome to another week that was in privacy.
Woohoo!
This week, Kay and I will look back at some of the most recent developments in the data protection community. We'll go into detail on the new data transfer guidelines of the European Data Protection Board. Yes, there are new ones again. We discuss some of the US state legislative developments. We look ahead at the new Indian data protection bill, and we discuss the consequences of the Dutch child benefits scandal. And to wrap up, there is some personal news. My name is Paul Breitbarth.
And I'm Kay Royal, and welcome to Serious Privacy. So, as Paul alluded to, or didn't allude to, flat out stated, this is a week where we don't have a guest on, so it is Paul and I, weekly update on privacy, and we have a lot of things we really want to talk about. So we're going to go to the unexpected question that I haven't prepared, so I'm going to randomly open to a page, and boom, there we go. What was the last thing you baked or cooked?
Well, this is gingerbread. It's Christmas time. So I baked gingerbread, and they are actually just out of the oven.
Oh, I can smell it.
So my house is smelling gingerbread.
Oh my goodness. On my side, the last thing I baked or cooked, Lord have mercy, was probably at Thanksgiving, because that was just a couple of weeks ago. And I typically only really bake or cook at big holidays, because Southern baking and cooking is a big production.
Also a greasy production.
It can be a very greasy production as well. Ours was really good. But today we're having a dinner to celebrate my birthday, which is tomorrow, and my mom is still here. She's leaving tomorrow, which is why we're not doing it then. But we're going to have pot roast and potatoes and carrots and homemade cake with caramel frosting and stuffed eggs. And I'm not doing a whole lot of the baking, but I'm going to count that one because my house is starting to smell really good right now.
It doesn't really smell like Christmas yet, but still it smells like good food.
Exactly. And we have a tradition that we don't put up the Christmas tree and stuff until my birthday, because that's, a little over 2 weeks in front of Christmas, and we usually did it. This week, I broke it. I put it up early since we're having a celebration today, and I'm going to have the extended members of my family here. So Juan is a guy that I mentored when he was in 5th grade through 8th grade. And then through my moves to Texas and California, we stayed in touch. He actually moved to California with us and started college there. And I consider him a son. So let's talk about what privacy happenings are happening this week. What's cooking in privacy, Paul?
Oh, a lot is cooking in privacy, Kay. A lot of is cooking in privacy. Let's start with maybe some of the most expected guidelines from the European Data Protection Board for this year, which...
Yes, and people may not understand what those actually stand for.
Well, these are the guidelines on the interplay between the application of Article 3 GDPR and the provisions on international transfers as per Chapter 5 of the GDPR. In other words, when does the GDPR actually apply, and when is a transfer?
Right.
That's a question that has been above the market for a very long time. And to be honest, I was rather disappointed by these guidelines. I was expected a very lengthy, thorough document that would provide a lot of use cases and a lot of detail. And we got 9 pages, including the cover and the table of content.
That's probably not the same reason I was disappointed.
And also because it is not the level of detail that I had hoped for. And we still do not have a definition of a data transfer. We do have 3 criteria, though, so it becomes a little easier to assess whether something is a transfer, but I'm not sure. Maybe this is what they could agree upon right now.
Right.
That is always a possibility. And maybe it is just that this is as far as they can go, or if they feel they can go right now.
Yeah. It looks like they did try to define transfer. They put some parameters around it. They quite often used it in quotation marks, so indicating that this might be an attempt at a definition, because under Section 3, starting with paragraph 19, they actually say, in quotes, that a transfer to a third country or to an international organization is a transfer if all the criteria identified by them in this guidance document is met. Thus, a transfer implies that personal data are sent or made available by a controller or processor regarding the given processing is subject to GDPR pursuant to Article 3 to a different controller or processor in a third country, regardless of whether or not the importer is subject to GDPR or not. And as a consequence, that controller or processor in a transfer situation needs to comply with the conditions of Chapter 5 and frame the transfer using the instruments which they call aim at protecting personal data after they've been transferred to a third country or international organization. So it seems like there is an attempt at defining what a transfer is. Not sure it's very clear to the readers that that's what they did.
No, and let's peel it down a little more, because also when summarizing it like that, I think people are losing track.
Oh, you mean the way it's written isn't perfectly...
Well, if you read it and sit down to it and sketch what it is actually saying, then maybe it is. But if you are just hearing this for the first time, maybe you are confused right now. And even if you have read it a few times, you might still be confused. So first of all, the EDPB there are 3 criteria basically in the opinion.
Yes.
1, there needs to be a data controller or a data processor that is subject to the GDPR for a processing operation.
Yes.
That makes sense. Otherwise, there is no processing operation. You would not have a data transfer.
As you're saying, if we're going to break it down to the basics here, and to be clear, this means that it is the activity or that transfer or that type of engagement that is subject to GDPR, not the company.
Correct.
So there you go.
It is GDPR applicability, especially when you look at Article 3.2, so extraterritorial scope, is always dependent on the processing operation and not on the full organization. So if there is a controller or processor that is subject to the GDPR for a processing operation, and they disclose by transmission or otherwise make available some personal data to another controller, a joint controller, or a processor in a third country, which is then considered to be the data importer, then you might have a transfer if that data importer in the third country is in a third country or is an international organization. And then it doesn't matter to which legal framework that data importer is subject. Now, let's also be clear. Third country means any country outside the European Economic Area.
Yes.
So the EU27 plus Norway, Liechtenstein, and Iceland, where the GDPR applies directly, there will never be a situation of a data transfer as long as they are part of that area.
And also, they make very, very clear that an individual cannot be one engaged. If it's disclosed directly by a data subject, there is no such thing as a data transfer.
No, correct. So that is also important to bear in mind. So only if there is an organization, a controller, a processor that has already collected personal data and then transmit that data to another controller or processor in a third country outside of the European Economic Area, in that situation, there is a data transfer that needs to be regulated. A direct collection from a company that is not established in the European Union of personal data that is from an individual who is in the European Union, that direct collection does not constitute a data transfer. It could still be subject to the GDPR by virtue of Article 3.2.
Right.
So it might still be that processing operation, that direct collection, needs to meet all the requirements of the GDPR. but it would not constitute a data transfer. So you cannot conclude standard contractual clauses with the individual, for example.
Yep, exactly. And then the third criteria, the first two criteria are located very early on in the document. They're very close together. Criteria 2 actually have a lot of scenarios that they present and examples where they're clarifying what it is they're talking about. And then you get down to the third criteria, which makes perfect sense.
That's usually after 1 and 2 that you get to 3. At least that's how I learned to count. And I think Sesame Street explained to you the same back in the days.
I was actually saying that the third criteria makes perfect sense, kind of like the first criteria does, that it only applies if there's an actual activity occurring. The third criteria actually states that someone has to be in another country.
Yes, that also makes sense. That's absolutely true too.
But okay.
So, if the
Don't laugh.
recipient, the data importer, is in the third country, then yes, then you would indeed have a transmission or a disclosure or whatever you can do from an organization within the European Economic Area, from the data exporter who is there to the data importer in the third country or an international organization.
And the other part is that international organization, a lot of people may not understand what that is. So it does not mean a global organization, such as a company that does business globally. It's actually talking about specific international organizations, such as the Red Cross, that Paul does a lot of training at. It could be others. There are lists of international organizations out there.
NATO, the United Nations, the Council of Europe, the Organization of American States.
Yeah. Doesn't matter where this organization is headquartered or where it has a subsidiary or anything. If it's given to an international organization, then that is considered a data transfer to essentially a data transfer to a third country. It's the same kind of concept.
They're at the
so
same
you
level.
have to take that into account.
And then it can become complex because a lot of international organizations do not want to be subject to any national jurisdiction. So there are also some that refuse to sign standard contractual clauses because that would make them subject to national jurisdiction.
And to them, that's a no-no in many cases.
Yeah. So that's for international organizations.
We don't think a lot of companies actually have that scenario where they're giving data to an international organization. But if you are, please be aware of this. And
so if you look at these guidelines in more detail, what you also quickly realize is that there might be a data transfer to where the full data processing operation would be subject to the GDPR because the recipient company, the data importer, would be offering goods or services to people in the European Union. Say a company offers online webinars and you have a registration form. No, that's a bad example. That's a direct collection.
That's a direct. Talk about cookies.
No, because that's e-privacy.
Yeah.
That's also not included. We're not going to give examples. Got.
Okay.
So, but what I try to explain, if the data importer is subject to the GDPR as well, that also means that it wouldn't make a lot of sense, as we've been saying all along, to have any of the traditional standard contractual clauses that help to not undermine the level of data protection given by the GDPR, because the GDPR will never be undermined just by complying with the GDPR.
Right.
The only undermining that would be possible is a conflict of law situation where the data importer in the non-European country that is subject for that processing operation to GDPR also has conflicting obligations under their national legislation. And that can still be problematic, and the current standard contractual clauses do not foresee that scenario.
Right.
So, here, we get another set of standard contractual clauses. Likely in the new year, I don't believe we'll find them under the Christmas tree.
Probably not.
To actually legalize that specific scenario. And those SCCs will mainly be focused on the security requirements. and the supplementary measures.
Do we anticipate that this module will lay on top of one of the other four, or is this a separate module?
No, I think from what I've heard, this will be a fifth module of standard contractual clauses. You would still need to do your transfer impact assessment because there could be those conflict of law situations that you will need to assess. And it might still mean that you need supplementary safeguards to put in place. But those would then not be directed to Article 46 of the GDPR, but much more to Article 32 on data security.
Right.
And that's another thing I've been saying for a while now, that in my view, it doesn't matter whether you transfer personal data or not. You will always need, when you process personal data from the European Union, you will always need those supplementary safeguards to be put in place because you don't know where the security services could be coming from.
Right.
They could be also domestic security services that may be touching your data or any of the EU member states. And let's not forget the scenario that some countries, including the United States, are tapping the transatlantic cables. So even if you are transferring from France to Ireland and your data is going via the transatlantic cable from France to Ireland, even then it is theoretically possible that the US would be intercepting that communication under Executive Order 12333. And also then you would need appropriate data security under 32 GDPR.
Absolutely. Absolutely. Security is always your friend. And being paranoid about what could possibly happen and trying to mitigate all possibilities is also your friend. And maybe you can't mitigate everything. I mean, let's be honest, that's kind of hard to do. But mitigate the most common, the most possible, the most probable, the most likely. Just take care of the data. And by the way, take a hard look at the data you have. And if you don't need it, don't collect it.
That's also always true.
Yeah. That there's a lot of data that we collect that we, the general companies, collect that you don't need to. So please take a hard look at your data and make sure that you need to collect it and then go back and get rid of the data you don't need. So aside from the EDPB guidelines, which came out a few weeks ago, and they're not as helpful as we would like them to be, there was another event that happened recently that we'd like to talk about. So it was a judicial decision, came out of a court. Near and dear to TrustArc's heart, talks about cookies. And so we would love to discuss this opinion that came out as well. And I don't believe it is public yet, so we might not be able to give you a link to it.
No, I haven't seen the full judgment of the Verwaltungsgericht Wiesbaden yet, which is the court of first instance in the city of Wiesbaden, which is in the state of Hessen in Germany. So this is really a first-level regional, and this was in an urgency procedure. So somebody complained to the court about a University of Applied Sciences using a cookie consent manager. It wasn't TrustArc's. We won't go into detail on whose it was, but the applicant basically requested the prohibition of the use of that cookie consent manager because there would be a data transfer to the United States. And on December 1st, the administrative court actually granted the application and prohibited the university to use that cookie service or cookie banner service on their website. And that is a pretty big decision.
Yeah.
There is only a press release, as you mentioned. So what we know is that in this case, there is a personal data transfer from the university to the platform that they use for cookie consent. The end user is clearly identifiable from a combination of a unique key identifying the website visitor, so basically the cookie ID, as well as the full IP address. And they were all stored on servers in the US. Now, what we don't know is to what extent the court made a detailed assessment of the arrangement that is in place here. We don't know, for example, if this university has actually put in place standard contractual clauses, whether they had done a risk assessment, whether any supplementary safeguards were put in place. The press release of the court doesn't specify. And we also don't know to what extent the court has actually assessed to what extent US legislation, surveillance laws like FISA 702, would actually cover this cookie data and the servers being used. Also, that we don't know from the press release. So it could be that the court just saw this data transfer to the US, recalled the Schrems decision, America bad, and said, oh, then you cannot transfer.
Right.
Without looking at the full detail. I hope that's not the case. I hope they are more diligent than that, but I haven't seen more detail.
And I hope we do get more detail, because just based on the information that we can see, and there may be more information we don't know, we haven't found it yet, but based on the information we do have, I mean, in particular, TrustArc doesn't store the full IP address. We also encrypt our data in motion and at rest.
And we host our cookie data in Europe.
And we host our cookie data out of the AWS in Ireland. And so there is customer service and support, should it be needed, that might be able to access it, but we don't actually engage in a lot of the other activities that they talk about. So hopefully those are differentiating factors, that we have it. More would be known if we can get to the full court decision. If it's ever made known, it might not be known, but there might be more information coming from the university, or there might be more information coming from the cookie consent company. And
I would expect that this decision will also be appealed.
Yeah.
And maybe even go to one of the European courts for a decision. One of the things also mentioned in the press release is that the court doesn't like the fact that the privacy notice of the university doesn't spell out any risks under the USA Cloud Act. And also there, I'm not even certain whether the USA Cloud Act would cover cookie data, or whether cookie data could be relevant. Yes, in theory, it could be that that IP address and user ID, so the profile that can be created on the basis of cookies, could tell a story of what kind of websites were visited. But whether that is really covered by the USA Cloud Act, and to what extent that full information could be subpoenaed by the US government, I'm just not.
Yeah, so it's interesting. The US Cloud Act will give you a link to this as well. So it actually was specifically put in place for overseas use of data to be able to give the US government access via a warrant or subpoena to data stored on service, regardless of whether the data was stored in the U.S. or on foreign soil. But it's also not just the U.S. I mean, the Cloud Act gives the equal protection to foreign governments to request data from U.S. tech companies, which I believe is actually more commonly what happens. One of the biggest things about the Cloud Act that people don't understand is there are exceptions built into it. So even if the servers are in another country, there are mechanisms for the courts to reject or to challenge the request or the warrant if they believe it violates the privacy rights of individuals in the other country. There is an actual streamlined process, and I don't know the details of any streamlined process that is currently negotiated with any countries. Forgive me on that. But there are streamlined processes with the Attorney General, the Secretary of State, if they agree that the foreign country has protections in place to restrict access to data related to United States citizens. So there's a lot of information on this. We'll make sure to give you the link on it. There's also a white paper that is available on this as well. But yeah, won't get into a whole lot of detail on the Cloud Act here, but just it was interesting that this came up in the decision that was made. So
yeah, that's the way it is. What else is new? Well, we saw the highest fine to date here in the Netherlands. A fine of 2.75 million euro on the Dutch tax administration. Once again, it's the Dutch tax authorities that have seen the wrath of the Dutch DPA. Previously, it was the processing ban on the national identification number for certain purposes. And now they have received a monetary fine.
Ooh.
And you can say, well, 2.75 million might not be that high. At the same time, this is, of course, a fine to a government authority that is payable to a government authority. So it doesn't really... Well, the fine itself is not so important. The signal that the Dutch DPA is giving with this particularly high fine from a Dutch perspective is. And the fine is actually imposed for discriminatory and unlawful data processing. And this is part of a scandal that's been been going around the Netherlands for over 2 years now, where childcare benefit applicants were blacklisted, especially because of dual nationality.
Ooh.
And a lot of people got into a lot of financial trouble, and also, by consequence of that, basically saw their lives destroyed.
Oh, no.
So this has been ongoing for a very long time. The data on dual nationality, according to the Dutch DPA, should already have been deleted back in January 2014, when the legal basis to process that information disappeared. Dual nationality, in any case, should not play a role in the assessment of childcare benefit applications. So that was a problem in itself. And by unnecessarily retaining such data, the nationality data in its systems, the tax administration also acted in a discriminatory way. Because entitlement to childcare under Dutch law is not contingent on nationality, it is contingent on where you live. So the chair of the Dutch DPA has actually said that digital applications have become indispensable, and they enable us to swiftly process and conveniently combine huge volumes of information. But when it goes wrong, it really goes wrong. And other fundamental rights can be affected too. The implications for individuals can be enormous, as the childcare benefit scandal has made painfully clear, end quote. So I'm happy that the Dutch DPA finally published their results and their decision in this case. It's been ongoing for a while, but it also shows that there are serious dangers involved in processing personal data using algorithms and AI, especially if people are faced by decisions that are only made by the algorithm. And apart from the fact that under the GDPR, of course, is not what is allowed, this whole situation shows that it can really, really go wrong.
So by this decision, which is the highest in your history, is that a final?
No, it's not final. It can always be appealed, because any administrative sanction from the DPA is appealable. But to be honest, I do not expect the government to appeal this. They would make a fool out of themselves with the whole. I mean, they've been working for a year now in trying to compensate all the parents that have been victims of this scandal, and they are not even at a third of what they should compensate and who they should compensate. It's going very slow. So if they would appeal this fine, they would really, really make fools of themselves.
Wow. I hope not then. I hope this helps bring some closure to at least parts of that.
And I hope it's a lesson learned that we shouldn't want to always close every single loophole in legislation up front, because if there is no leeway for a human-based decision, then you can also not easily resolve these kind of issues. And there are some bills still pending in Parliament that bear the risk of actually creating new scandals like these in the years to come.
Well, it's not unheard of in any courts. I mean, we have the same thing here in the U.S. with mandatory sentencing and guidelines. And it can be very hard when you can't take into account the human being behind it and make some exceptions. And I've heard stories, seen in person, judges that their hands are tied. They can't do anything because it's mandatory.
Still people and not a number or a digit or whatever.
Exactly. They're still humans there, and that should always be taken into account.
Hey, and that's why you and I are still in data protection, because we are actually working with data of people, and we are here to fight for their rights.
Exactly. Helping profession, as always, helping profession.
Exactly, and we'll continue doing that. What else is new on your side of the world?
So on my side of the world, we don't have a whole lot of things really moving and grooving right now when you think about it. We still don't have any legislation that would impact the US-EU Privacy Shield. We also don't have any new state laws that have passed with their privacy omnibus, although I believe it is still hopeful that Ohio is in the running.
Have we lost momentum a little?
I believe we have lost momentum some, but it's not unexpected. We knew that seeing legislation come out in the latter part of the year is unusual. It's limited to those states that actually have a full year Congress, but we've entered the holiday season.
Yep.
You know, once Thanksgiving hits, there's not a whole lot of momentum on a whole lot of things. unless they really, really, really wanted to get it out the door.
And luckily next year is an election year again, right? So
I hope so. I really hope that we're going to see more for that. I'm looking for an update on the Ohio law, and I'm not seeing a whole update on the Ohio law. The last I see is an update in October of any movements, but I'll go look at the actual law and see if we're seeing anything there.
So another thing that may be happening still this year, if you talk about momentum, is the India law. We've been talking about it for about a year, that it would happen in 2022, and the Indian Congress is really making it difficult to meet that deadline.
Yes.
They are now scheduling the debate for December 21st, but it is still possible. Indian Congress closes their winter session on December 23rd, so it is still possible that before Christmas we see the adoption of the Indian Personal Data Protection Act that it will then become. So it is in the works. There is still some debate, especially on some of the final detailed provisions, also some of the transfer provisions, I understand. But people are hopeful that indeed the Winter Congress in India may actually adopt this legislation. And from the moment it is adopted, it will be 2 years before it fully enters into application. So if that happens by the end of this year, then we'll probably have one of our first episodes of season 3 dedicated to the Indian law and tell you all about it in more detail.
And that is what a reasonable law would do, is get passed and then give some time for companies and people and other interested parties to actually assess what they have, put measures in place, and perhaps be compliant in a year or 2 years. I mean,
what do you mean? 76 days is not enough? 74?
Not that I would ever criticize China for the very quick implementation timeline, but I also haven't...
Very efficient.
Yeah, they're very efficient. There we go. But I also haven't seen any enforcement activity coming out.
Well, I mean, you cannot expect... I mean, the law has been in force for 39 days. So, I mean, preparation of 76, you can't expect enforcement in 39 days after those 76.
Yeah.
That also takes a bit of time.
But, you know, there have been laws that as soon as they went into effect, boom, letters and investigations started the next day and government made announcements about it. So I hope this is a good sign that maybe they're taking a very methodical. Maybe this is a sign they're taking a methodical and deliberate approach to enforcement activities and just not enforcing willy-nilly.
Or maybe they just don't announce every step that they take and they will suddenly hit with sanctions. Because also not all DPAs in Europe or in the US, any attorney general would always announce the investigations that they are conducting. Sometimes
that is
you
very
are just
true.
Surprised with the final sanction.
That is very true. So I'm looking back at Ohio, and it looks like it has had its second hearing in the Government Oversight Committee at the end of October. The third hearing was yesterday, December the 8th. And then the fourth hearing is today, December 9th, as we are. So it's progressing, but it doesn't look like it's going to, be on fire here soon. So love that. Let's talk a little bit about, I know we don't have a lot of time left, so rather than talking about privacy predictions, which we may save for the next episode, Paul, how about if we go ahead and let our listeners know of a little bit of news that you have?
Yeah, sure. And that is that...
Take a deep breath, everyone.
We will be back with season 3 next year. That is part of the news. But I will no longer be with TrustArc. I'm leaving the company at the end of the year. After 5.5 years, first with Nimity, now with TrustArc. It's been not an easy decision, but it's also not been an easy time the past 2 years because of the pandemic. This is only due to the pandemic.
Has nothing to do with TrustArc.
No, it's not. It's nothing to do with Kay.
Well, yeah, well.
It's nothing to do with all the other amazing colleagues. It's nothing to do with the products and the amazing teams developing them and supporting them. But being out here in Europe as one of the only people we have in Europe, and the other people that are here are not part of the teams that I frequently work with. it just makes it really difficult. My workday more or less ends by the time that your workday and those of most of the other colleagues start, at least on paper, which means that I work a lot of nights, which in itself is not a problem once in a while or on fixed days every week. But if it's almost every, and if you don't see any colleagues in person, which is basically what happened for the past 2 years, I mean, we joked about it a lot, and there is a lot to joke about. But I also realized these past couple of months that it's becoming more and more difficult to keep that going.
Yeah.
So when I got an offer from a company here in the Netherlands to go in-house and run a privacy program myself, meaning that I would need to eat my own dog food or drink my own champagne, whatever way you look at it, and start actually implementing all those recommendations that I give to others on how to run a privacy program successfully, I thought, well, maybe that is what I should do. So I've accepted, and as of the new year, I will be working for a local company here in the Netherlands, a tech scale-up, and going to B2C, business to consumer, instead of B2B. So it will be a big change.
However,
the podcast can continue.
Podcast will continue with Paul.
Both companies agreed that we will continue to do the podcast. So yes, there will be a Serious Privacy Season 3, just with Kay and me and all of our guests and all of our jokes and all of our conversations. It will just be slightly different.
Right. And so I'll still get to see Paul at least on a weekly basis over video. And at some point when there's in-person things that can happen again, we still plan to get together and make sure that we see each other. And yes, we showed up at work today wearing the same colors yet again. So I will say that 2 things come out of this. I mean, I can't even go into how this impacts me personally. We're going to leave that unsaid, just that I will miss him amazingly as a colleague. So, I do understand, but this is also indicative of what we've seen around the world, not just people changing jobs and resigning, but the impact that the isolation is having on people, especially even introverts are tired of this. Let's just be honest, but especially extroverts are suffering a lot. They need that contact. They need other people. This is a fundamental part of their being. So I can't hold this against Paul at all.
And yet you do.
And yet I do. So we'll just leave it there. But I am
soldier on.
Yeah. I'm absolutely thrilled. We're going to continue with the podcast. We're going to continue to bring you all the wonderful things that we're doing and talking.
Hey, and I may have better perspective next year because I'm actually doing some of the work myself. So
yes. So for all of you that run privacy programs, now you know Paul will feel your pain.
You never know.
He hasn't been doing that. He's over policy and strategy here, looking at impacts and how things go, but typically not involved in the day-to-day management of our privacy program, although he does get a little bit of blowback there, here and there.
Yeah, we'll see what next year will bring. But yeah, that is my big news at the end of the year. It's going to be difficult.
We still have episodes coming this year. I think we still have 2 episodes coming.
One after that.
Paul says 1. I say 2. We'll see how this works out because we don't want to be recording and working over the holidays. So we'll see how this works out. But the 2 that I want to have coming are, and maybe we combine them, is our best episodes of this past year. And so we need to take the time and pull those clips for y'all so you have that. So our best episodes of the year, but then also I want privacy predictions for 2022. We just had a webinar on it on TrustArt yesterday that Paul led. Fabulous webinar. We'll make sure to give you the links in the description as well for that. Please make sure you tune in and watch that. It's awesome. But the predictions Paul and I will do. Paul, you didn't actually provide your predictions, did you?
I did not. I mainly moderated the webinar.
That's what I was thinking. So I didn't recall hearing any. And so this is going to be interesting. We're going to give our predictions. We may also talk on a little bit of predictions for legal tech for 2022, because I do that on an annual basis as well for the Association of Corporate Counsel. So we'll look at those as well, but also our favorite episodes. So please, I know there's a lot of you out there that don't ever comment, but you love the episode. Let us know what's your favorites. We can't just go by the ones with the biggest listens, although that's slightly indicative. But please let us know which ones you really enjoyed. You can let us know which ones you hated too, but we're not going to talk about the most hated episodes.
No,
We're going to talk about the most favorite ones.
exactly. And we'll do that. And indeed, you can find us on LinkedIn. That's the best place to tell us what your favorite fragments are of the past year. What are your favorite clips? Who was your favorite? Tell us. Look at LinkedIn for Serious Privacy and join the conversation there, or tweet us at Podcast Privacy. You'll find Kay on Twitter as Heart of Privacy and myself as EuroPaulB. And if you have any other questions or suggestions, reach out to us as well. For now, this was another episode of Serious Privacy, and we look forward to be back with you just before Christmas with some more episodes. Thank you for now, and until our next episode. Bye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.